are. Oh, no, we're not. He's putting the microphone. Oh, hey, what the heck is going on? You Daddy. It's all a mess. Is that working? Murmur. Hey, Johnny. It is the 31st of January, folks. Last day of January. The last day of January is a Friday this year. There are 277 days until Election Day. 277 days till Election Day. We are here today considering the impeachment of Donald J. Trump, President of the United States of America, who stands accused of abusing his power. A specific instance of the manipulation of a meeting with the president of Ukraine and aid dedicated to Ukraine.
Since the age of 21. And I was thinking of a music lyric earlier today from my youth. It goes something like this. Hold on. We're moving too fast. Gotta make democracy last. Hold on. Moving too fast. Gotta make democracy last. Song of the day. Hey, song of the week.
Senator, how long do you think it'll last today? What do you think the timeline would be?
Maybe 8 o'clock, but we'll see. This is moving so fast. I don't think we really know. The way things are going, who knows?
And there you have it, just outside the Senate
Senator
chambers.
Carper, you saw just a moment ago, Senator
This is,
Blunt
of
of Missouri.
course, C-SPAN coverage that we use. C-SPAN is a nonprofit found at cspan.org, cspan.org. I highly recommend you join the community there and contribute to this nonprofit, which was started during the era of cable television, brought us C-SPAN, 1979. And what's beautiful about it is they have cameras situated there, but the cameras are in the control of the Senate itself. So when it's ready to go, they turn it on, and we wait for that to happen here as the senators are arriving for day 11 of the impeachment trial. In summary, last night, a senator who would have made a difference announced that he would not be supporting the subpoena ability to bring witnesses. This changes the math. Lamar Alexander of Tennessee brought all the media to his door and crushed the hopes of the Democrats by saying he thinks that what Donald Trump has done is wrong, but that it doesn't rise to the level of an impeachable offense, and that he had seen 200 or more videos and listened to 9 or 10 days of testimony from the House managers, and he didn't need any more to know that Donald Trump has done something wrong, but it didn't rise in his mind to the level of an impeachable offense. Now, without him, they say, the partisanship of this matter has it that the vote, which will likely happen today, will not allow for witnesses in the trial, which would, in fact, be as unprecedented as the trial itself is. And as we await that, let's see if they're saying some more outside the chambers here. Can we see who that is? Is that one of the president's counsel? Again, the two sides here are the House managers, who are coming from the House of Representatives, and they're bringing with them the impeachment charges and presenting the case for impeaching and removing Donald Trump from the office of the presidency. Their charges are very specific, and they relate to elections-related material, which is why they felt it had to be done now, because we have an election in 277 days. Now, the votes aren't there. In order to remove the president, they would need 2/3 of the senators, which would require significantly more bipartisan participation. 20 Republicans would be required to achieve that. So it is looking as if, from speculation by media members and the statements
outside the Senate chamber
of Lamar
Alexander,
Alexander,
Chief Justice John Roberts,
that Donald J. Trump
with Reverend
will be
Black, the Senate
acquitted.
chaplain, and the afternoon prayer to start the session. I'm going to read to you what the New York Times is reporting because it will be coming up during the course of the debate this afternoon. Maggie Haberman, based on new revelations from John Bolton's book, more than 2 months before he asked Ukraine's president to investigate his political opponent, President Trump directing John Bolton, then his national security advisor, to help with his pressure campaign to extract damaging information on Democrats from Ukrainian officials. Mr. Trump giving that instruction, according to the New York Times, in Mr. Bolton's book, during an Oval Office conversation in early May that included the acting White House Chief of Staff, Mick Mulvaney, the president's personal lawyer, Rudy Giuliani, and White House counsel, who's now taking the lead in this Senate trial for the president, Pat Cipollone, who is now the impeachment defense manager for the president.
Wow.
New York Times pointing out that Mr. Bolton was asked to call President Zelensky, who had recently won election as the president.
Turn to our death, that would be a good thing.
Taken now to the floor of the U.S. Senate for this afternoon's proceedings. More details at nytimes.com.
Interesting the choice there. C-SPAN is not biased, generally speaking. It is, in fact, quite nonpartisan. It makes an effort to be quite nonpartisan. They'll read from the Post or from the Times. The senators are all there now. They're being asked to rise as the Chief Justice enters the chamber.
The Senate will convene as a court of impeachment. The chaplain will lead us in prayer.
Let us pray. Eternal Lord God, you have summarized ethical behavior in a single sentence. Do for others what you would like them to do for you. Remind our senators that they alone are accountable to you for their conduct. Lord, help them to remember that they can't ignore you and get away with it. For we always reap what we sow. Have your way, mighty God. You are the potter, our senators, and we are the clay. Mold and make us after your will. Stand up, omnipotent God. Stretch yourself and let this nation and world know that you alone are sovereign. I pray in the name of Jesus. Amen.
Amen. Please join me in reciting the Pledge of Allegiance to the flag. I pledge allegiance to the flag of the United States of America,
Republic for which it stands, one nation under God, indivisible, with liberty and justice for all. And away we go. Senate impeachment trial, day 11.
Senators, please be seated. If there is no objection, the journal of proceedings of the trial are approved to date. The Deputy Sergeant at Arms will make the proclamation.
Hear ye, hear ye, hear ye. All persons are commanded to keep silent on pain of imprisonment while the Senate of the United States is sitting for the trial of articles of impeachment exhibited by the House of Representatives against Donald John Trump, President of the United States.
The majority leader is recognized.
For the information of all colleagues, we'll take a break about 2 hours out.
Pursuant to the provisions of Senate Resolution 483, the Senate has provided up to 4 hours of argument by the parties equally divided on the question of whether or not it shall be in order to consider and debate under the impeachment rules any motion to subpoena witnesses or documents. Mr. Manager Schiff, are you a proponent or opponent? Mr. Cipollone, are you a proponent or opponent? Thank you. Then Mr. Schiff, you may proceed.
Before I begin, Mr. Chief Justice, the House managers will be reserving the balance of our time to respond to the argument of counsel for the President. Mr. Chief Justice, senators, fellow House managers, and counsel for the President, I know I speak for my fellow managers as well as counsel for the President in thanking you for your careful attention to the arguments that we have made over the course of many long days. Today, we were greeted to yet another development in the case when the New York Times reported with a headline that says, "Trump told Bolton to help his Ukraine pressure campaign," book says. The president asked his national security advisor last spring in front of other senior advisors to pave the way for a meeting between Rudolph Giuliani and Ukraine's new leader. According to the New York Times, more than 2 months before he asked Ukraine's president to investigate his political opponents, President Trump directed John R. Bolton, then his national security advisor, to help with his pressure campaign to extract damaging information on Democrats from Ukrainian officials, according to an unpublished manuscript by Mr. Bolton. Mr. Trump gave the instruction, Mr. Bolton wrote, during an Oval Office conversation in early May that included the acting White House Chief of Staff, Mick Mulvaney, the president's personal lawyer, Rudy Giuliani, and the White House counsel, Pat Cipollone, who is now leading the president's impeachment defense. Now, you will see in a few moments, and you will recall Mr. Cipollone suggesting that the House managers were concealing facts from this body. He said all the facts should come out. Well, there's a new fact which indicates that Mr. Cipollone was among those who were in the loop. Yet another reason why we ought to hear from witnesses. Just as we predicted, and it didn't require any great act of clairvoyance, the facts will come out. They will continue to come out. And the question before you today is whether they will come out in time for you to make a complete and informed judgment as to the guilt or innocence of the president. Now, the Times article goes on to say that Mr. Trump told Mr. Bolton to call Vladimir Zelensky, who had recently won election as president of Ukraine, to ensure Mr. Zelensky would meet with Mr. Giuliani, who was planning a trip to Ukraine to discuss the investigations that the president sought in Mr. Bolton's account. Mr. Bolton never made the call, he wrote. Never made the call. Mr. Bolton understood that this was wrong. He understood that this was not policy. He understood that this was a domestic political errand and refused to make the call. The account in Mr. Bolton's manuscript portrays the most senior White House advisors as early witnesses in the effort that they have sought to distance the president from, including the White House counsel. Over several pages, according to the Times, Mr. Bolton laid out Mr. Trump's fixation on Ukraine and the president's belief, based on a mix of scattershot events, assertions, and outright conspiracy theories, that Ukraine tried to undermine his chances of winning the presidency in 2016. As he began to realize the extent and aims of the pressure campaign, Mr. Bolton began to object. He wrote in the book, affirming the testimony of a former National Security Council aide, Fiona Hill, who had said Mr. Bolton warned that Mr. Giuliani was a hand grenade who's going to blow everybody up. Now, as you might imagine, the president denies this. The president said today, "I never instructed John Bolton to set up a meeting for Rudy Giuliani, one of the greatest corruption fighters in America." So here you have the president saying John Bolton is not telling the truth. Let's find out. Let's put John Bolton under oath. Let's find out who's telling the truth. The trial is supposed to be a quest for the truth. Let's not fear what we will learn. As Mr. Cipollone said, let's make sure that all the facts come out.
Mr. Chief Justice, Senators, Counsel for the President, last Tuesday at the onset of this trial, we moved for Leader McConnell's resolution to be amended to subpoena documents and witnesses from the outset. This body decided to hold the question over. You have now heard opening arguments from both sides. You have seen the evidence that the House was able to collect. You have heard about the documents and witnesses President Trump blocked from the House's impeachment inquiry. We have vigorously questioned both sides. The President's counsel has urged you to decide this case and render your verdict upon the record assembled by the House. The evidence in the record is sufficient. It is sufficient to convict the President on both articles of impeachment, more than sufficient. But that's simply not how trials work. As any prosecutor or defense lawyer would tell you, when a case goes to trial, both sides call witnesses and subpoena documents to bring before the jury. That happens every day in courtrooms all across America. There is no reason why this impeachment trial should be any different. The common sense practice is born out of precedents. There has never before been a full Senate impeachment trial without a single witness. In fact, you can see in the slide, in every one of the 15 prior impeachment trials, the Senate has called multiple witnesses. Today, we ask you to follow this body's uniform precedents and your common sense. We urge you to vote in favor of subpoenaing witnesses and documents. Now, I'd like to address one question at the offset. There has been much back and forth about whether, if the House believes it has sufficient evidence to convict, which we do, why do we need more witnesses and documents? So I'd like to be clear. The evidence presented over the past week and a half strongly supports a vote to convict the president. The evidence is overwhelming. We have a mounting of evidence. It's direct, it's corroborated by multiple sources, and it proves that the president committed grave, impeachable offenses to cheat in the next election. The evidence confirms that if left in office, President Trump will continue to harm America's national security. He will continue to seek to corrupt the upcoming election, and he will undermine our democracy, all to further his own personal gain. But this is a fundamental question that must be addressed. Is this a fair trial? Is this a fair trial? Is this a fair trial? Without the ability to call witnesses and produce documents, the answer is clearly and unequivocally no. It was the president's decision to contest the facts, and that is his right. But because he has chosen to contest the facts, he shall not be heard to complain. He shall raise. He complains that few witnesses spoke to.
Oh, sorry, folks. We got to freeze. I'm going to give it just a second here. We are attempting to watch.
Then the witnesses the House wishes to call directly to the president's own words, his own admissions of guilt, his own confessions of responsibility. If they did not, all the president's men would be on their witness list, not ours. These witnesses and the documents their agencies produce tell the full story. And I believe that we are interested in hearing the full story. You should want to hear it. More than that, the American people, we know they want to hear it.
He is not offline.
The House Republicans' own expert witness in the House, Professor Turley, said if you could prove the president used our military aid to pressure Ukraine to investigate a political rival and interfere in our elections, it would be an impeachable abuse of power. And Senator Graham, too, recognized that if such evidence existed, it could potentially change his mind on impeachment. Well, we now have another witness, a fact witness, who would reportedly say exactly that. Ambassador Bolton's new manuscript, which we will discuss in more detail in a moment, reportedly confirms that the president told him in no uncertain terms. We're talking about the former national security advisor saying the president told him in no uncertain terms, no aid until investigations, including the Bidens. For a week and a half, the president has said no such evidence exists. They are wrong. But if you have any doubt about the evidence, the evidence is at your fingertips. The question is, will you let all of us, including the American people, simply hear the evidence and make up their own minds? And you can make up your own minds, but will we let the American people hear all of the evidence? You'll recall that Ambassador Bolton, the president's former national security advisor, is one of the witnesses we asked for last Tuesday. We did not know at the time what he'd say. We didn't know what kind of witness that he would be, but Ambassador Bolton made clear that he was willing to testify and that he had relevant firsthand knowledge that hadn't yet been heard. We argued that we all deserve to hear that evidence, but the president opposed him. Now we know why.
Yeah.
Because John Bolton could corroborate the rest of our evidence and confirm the president's guilt. So today, senators, we come before you and we argue again that you let this witness and the other key witnesses we have identified come forward so you have all of the information available to you when you make this consequential decision. If witnesses are not called here, these proceedings will be a trial in name only. And the American people clearly know a fair trial when they see one. Large majorities of the American people want to hear from witnesses in this trial, and they have a right to hear from witnesses in this trial. Let's hear from them. Let's look them in the eye, gauge their credibility, and hear what they have to say about the president's actions. For the same reasons, this body should grant our request to subpoena documents. The documents that the president also blocked the House from obtaining. Documents from the White House, the State Department, DOD, and OMB that will complete the story and provide the whole truth, whatever they may be. We ask that you subpoena these documents so that you can decide for yourself. If you have any doubt as to what occurred, let's look at this additional evidence. To be clear, we're not asking you to track down every single document or to call every possible witness. We have carefully identified only 4 key witnesses with direct knowledge who can speak to the specific issues that the president has disputed. And we targeted key documents, which we understand have already been collected. For example, at the State Department, they've already been collected. This will not cause a substantial delay. As I made clear last night, these matters can be addressed in a single week. As we made clear last night, these matters can be addressed in a single week. We know that from President Clinton's case. There, the Senate voted to approve a motion for witnesses on January 27. The next day, it established procedures for those depositions and adjourned as a court of impeachment until February 4. In that brief period, the parties took 3 depositions. The Senate then resumed its proceedings by voting to accept the deposition testimony into the record. In this trial too, let's do the same. We should take a brief 1-week break for witness testimony and document collection, during which time the Senate can return to its normal business. The trial should not be allowed to be different from every other impeachment trial or any other kind of trial, simply because the president doesn't want us to know the truth. The American people that we all represent, the American people that we all love and care about, deserve to know the truth. And a fair trial requires it. This is too important of a decision to be made without all of the relevant evidence. Before turning to the specific need for these witnesses and documents, I want to make clear we are not asking you again to break new ground. We're asking quite the opposite. We are asking you to simply follow the Senate's unbroken precedents and to do so in a manner that allows you to continue the Senate's ordinary business. The Senate, sitting as a court of impeachment, has heard witness testimony in every other, as we've said earlier, in every other 15 impeachment trials in the history of the Republic. And in fact, these trials have had an average of 33 witnesses. And the Senate has repeatedly subpoenaed and received new documents while adjudicating cases of impeachment. That makes sense. Under our Constitution, the Senate does not just vote on impeachments. It does not just debate them. Instead, the Senate is commanded by the Constitution to try all cases of impeachment. Well, a trial requires witnesses. A trial requires documents. This is the American way, and this is the American story. If the Senate denies our motions, it would be the only time in history it has rendered a judgment on articles of impeachment without hearing from a single witness or receiving a single relevant document from the president whose conduct is on trial. And why? How can we justify this break from precedents? How would we justify, for what reason would we break precedents in these proceedings? There are many compelling reasons beyond precedent that demand subpoenas for witnesses and cases and documents in this case. And at this time, I yield to Manager Garcia.
Mr. Chief Justice, President's Council, Senators. Last week, I shared with you that I was reflecting on my first days at a school for baby judges. Y'all may recall that. And I mentioned to you that one of the first things they told us was that we had to be good listeners and be patient. And you as judges in this trial have certainly passed the test. Thank you for being good listeners and for being patient with us. It's been quite a long journey, but we're here today to talk about the other thing they told us in baby judge school, and that was that we had to give all the parties in front of us a fair hearing, an opportunity to be heard, an opportunity to cross-examine witnesses, an opportunity to bring evidence. And that's what I want to talk to you about today. Because in terms of fundamental fairness, subpoenas by the Senate in this trial would mitigate the damage caused by the president's wholesale obstruction of the House inquiry.
Thank you.
The president claims that there is no direct evidence of his wrongdoing, despite direct evidence to the contrary, and Ambassador Bolton's offer to testify to even more evidence in a trial. But let's not forget that the president is arguing that there is no direct evidence while blocking all of us from getting direct evidence.
Thank you.
It's a remarkable position that they have taken. Quite frankly, never, as a lawyer or a former judge, have I ever seen anything like this. And for the first time in our history, President Trump ordered his entire administration to defy every single impeachment subpoena. The Trump administration has not produced a single document in response to the congressional subpoenas. Not a single page, nada. That's never happened before. There is no legal privilege to justify the blanket blocking of all of these documents. We know that there are more relevant documents. There is no dispute about that. It is uncontested. Witnesses have testified in exceptional detail about these documents that exist that the president is simply hiding. President Trump's blanket order prohibiting the entire executive branch from participating in an impeachment investigation also extended to witnesses. 12 in all followed that order and refused to testify. Much of the critical evidence we have is a result of career officials bravely coming forward despite the president's obstruction. But those closest to the president, some may say, like in the musical Hamilton, those in the room when it happened, followed his instruction. The president does not dispute that these witnesses have information that is relevant to this trial, that these individuals have personal and direct knowledge of the president's actions and motivations and can provide the very evidence he says now that we don't have. Now, the president's counsel alleged the House managers hid evidence from you.
Because House managers, really, their goal should be to give you all of the facts, because they're asking you to do something very, very consequential. And ask yourself, given the facts you heard today that they didn't tell you, who doesn't want to talk about the facts? Who doesn't want to talk about the facts? Impeachment shouldn't be a shell game. They should give you the facts.
This is nice rhetoric, but it's simply incorrect. The President's Counsel cherry-picked misleading bits of evidence, cited disposition transcripts of witnesses who subsequently corrected their testimony in public hearings, and said the opposite, and in some cases simply left out the second half of witness statements. That's how the House managers accurately presented the relevant evidence to you. We spent about 20 hours presenting the facts and the evidence. The President's Counsel spent 4 hours focusing on the facts and the evidence. And that evidence shows that the President is guilty. But to the extent certain facts were shown to you, let's be very clear. We are not the ones hiding the facts. The House managers did not hide that evidence. President Trump hid the evidence. And that's why we are the ones standing up here asking you to not let the president silence these witnesses and hide these documents. We don't know precisely what the witnesses will say or what the documents will show, but we all deserve to hear the truth. And more importantly, the American people deserve to hear the truth. Never before has the president been put himself above the law and hid the facts of his offenses from the American people like this one. We cannot let this president be different. Quite simply, the stakes are too high. Second, as this builds on what we have been arguing, the Senate requires and should want a complete evidentiary record before you vote on the most sacred task that the Constitution entrusts in every single one of you. I can respect that some of you have deep beliefs that the removal of this president would be divisive. Others, you may believe that allowing this president to remain in the Oval Office would be catastrophic to our republic and our democracy. But regardless of where you are, or regardless of where you land on this spectrum, you should want a full and complete record before you make a final decision and to understand the full story. It should not be about party affiliation. It should be about seeing all the evidence and voting your conscience based on all the relevant facts. It should be about doing impartial justice. Consider the harm done to our institutions, our constitutional order, and the public faith in our democracy. If the Senate chooses to close its eyes to learning the full truth about the president's misconduct, how can the American people have confidence in the result of a trial without witnesses? Third, the president should want a fair trial. He has repeatedly said that publicly, that he wants a trial on the merits. He specifically said it, you saw a clip, that he wanted a fair trial in the Senate. And that would have to be with witnesses that testify, including John Bolton and Mick Mulvaney. He said that he wants a complete and total exoneration. Well, whatever you say about this trial, there cannot be an exoneration without hearing from those witnesses, because an acquittal on an incomplete record after a trial lacking witnesses and evidence will be no exoneration. It will be no vindication, not for the president, not for this chamber, and not for the American people. And if the president is telling the truth and he did nothing wrong, and the evidence would prove that, then we all know that he would be an enthusiastic supporter of subpoenas. He would be here probably himself, if he could, urging you to do subpoenas if he had information that would prove he was totally not in the wrong. If he is innocent, he should have nothing to hide. His counsel should be the ones here asking today to subpoena Bolton and Mulvaney and others for testimony. The president would be eager to have the people closest to him to testify about his innocence. He would be eager to present the documents that show he was concerned about corruption and burden sharing. But the fact that he has so strenuously opposed the testimony of his closest advisors and all the documents speaks volumes.
Yes, it does.
You should issue subpoenas to the president so that the president can get the fair trial that he wanted. But more importantly, so the American people can get the fair trial that they deserve. The American people deserve a fair trial. I said at the onset of this trial that one of the most important decisions you would make at this moment in history will not be whether you convict or acquit, but whether the president and the American people will get a fair trial. The process is more than just the ultimate decision, because the faith in our institution depends on the perception of a fair process. A vote against witnesses and documents undermines that faith. Senators, the American people want a fair trial. The overwhelming majority of Americans, 3 in 4 voters, 3 in 4, as of this past Tuesday, believe that this trial should have witnesses. Now, there's not much that the
75%
American
of
people
America.
agree on these days, but they do agree on that. And they know what a fair trial is. That involves witnesses and it involves evidence. The American people deserve to know the facts about their president's conduct and those around him. And they deserve to have confidence in this process, confidence that you made the right decision. In order to have that confidence, the Senate must call relevant witnesses and obtain relevant documents withheld thus far by this president. The American people deserve a fair trial. I now yield to my colleague, Manager Parsons.
I mean, it's just hard for me to speak positively about the United States and what its government and its rules are.
Mr. Chief Justice,
At a
members
time
of the
like
Senate,
this.
counsel for the president. Last week, the House managers argued for the testimony of 4 witnesses:
Can't take it.
Ambassador
I
John
gotta make a
Bolton,
phone call.
Mick Mulvaney, Robert Blair, and Michael Duffy. And during the presentations from both parties, it has become abundantly clear why the direct testimony from those witnesses is so critical. And new evidence continues to underscore that importance. So let's start with John Bolton. The President's counsel has repeatedly stated that the president didn't personally tell any of our witnesses that he linked the military aid to the investigations.
There is simply no evidence anywhere that President Trump ever linked security assistance to any investigations. Most of the Democrats' witnesses have never spoken to the president at all, let alone about Ukraine security assistance. Not a single witness testified that the president himself said that there was any connection between any investigations and security assistance, a presidential meeting, or anything else.
Simply not true, as the testimony of Ambassador Sondland and the admission of Mick Mulvaney make very clear. The evidence before you proves that the president not only linked the aid to the investigations, he also conditioned both the White House meeting and the aid on Ukraine's announcement of the investigations. But if you want more, a witness to acknowledge that the president told them directly that the aid was linked, a witness in front of you, then you have the power to ask for it. I mentioned this portion, there's a slide, I mentioned this portion of Ambassador's manuscript in the beginning, and Manager Schiff referenced it as well. But he says directly that the president told him this. Now, the president has publicly lashed out in recent days at Ambassador Bolton. He says that what Ambassador Bolton is saying is nasty and untrue. But denials in 280 characters is not the same as testimony under oath. We know that. Let's put Ambassador Bolton under oath and ask him point blank. Did the president use $391 million of taxpayer money, military aid intended for an ally at war, to pressure Ukraine to investigate his 2020 opponent? The stakes are too high not to. I'd like to briefly walk you through why Ambassador Bolton's testimony is essential to ensuring a fair trial. Also addressing some of the questions that you've asked in the past 2 days. First, turning back to Ambassador Bolton's manuscript. The President's Counsel has said no scheme existed. And the President's Counsel has cited repeated denials, public denials of President Trump's inner circle about Bolton's allegations. None of them, of course, under oath. And as we know from the testimony of Ambassador Bolton, how important being sworn in really is. But Ambassador Bolton, as the top national security aide, has direct insight into the president's inner circle. And he is willing to testify under oath whether, quote, everyone was in the loop, as he testified before. Ambassador Bolton reportedly knows, quote, new details about senior cabinet officials who have publicly tried to sidestep involvement, end quote, including Secretary Pompeo and Mr. Mulvaney's knowledge of the scheme. Second, Ambassador Bolton has direct knowledge of key events outside of the July 25th call that confirm the president's scheme. Remember, this is exactly the type of direct evidence the President's Counsel say doesn't exist. That's partly because they would like you to believe that the July 25th call makes up all of the evidence of our case. The call, of course, is just a part of the large body of evidence that you've heard about the past week, but it is a key part. But Ambassador Bolton has critical insight into the president's misconduct outside of this call, and you should hear it. Take, for example, the July 10th meeting with U.S. and Ukrainian officials at the White House. Dr. Hill testified during the meeting that Ambassador Sondland said that he had a deal with Mr. Mulvaney to schedule a White House meeting if the Ukrainians did the investigations. According to Dr. Hill, when Ambassador Bolton learned this, he told her to go back to the NSC's legal advisor, John Eisenberg, and tell him, quote, I am not a part of whatever drug deal Sondland and Mulvaney are cooking up on this, end quote. We already have corroboration of Dr. Hill's testimony from other witnesses like Lieutenant Colonel Vindman. And we have new corroboration from Ukraine too. Oleksandr Daniluk, President Zelensky's former national security advisor, recently confirmed in an interview that the, quote, roadmap for U.S.-Ukraine relations should have been the substance, but the investigations were raised, end quote. Daniluk also explained why this was so problematic. He raised concerns that being, quote, dragged into this internal process would be really bad for the country. And also, if there's something that violates U.S. law, that's up to the U.S. to handle, end quote. Daniluk elaborated that there were serious things to discuss at the meeting. But if instead Ukraine was being dragged into, quote, internal politics using our president who is fresh on the job, inexperienced, that could just destroy everything, end quote. Another key defense raised by the president has been that Ukraine felt no pressure, that these investigations are entirely proper. Well, here's Ukraine saying the opposite of that. You know what else Daniluk said in the interview? Quote, it was definitely John who I trusted, end quote. Talking about Ambassador Bolton. So if you want to know whether Ukrainians felt pressured, call John Bolton as a witness. He was trusted by Ukraine and he was there for these key meetings. And he was so concerned that he characterized the scheme as a drug deal and urged Dr. Hill and others to report their concerns to NSC legal counsel, who reports to White House counsel Cipollone. So let's ask Ambassador Bolton these questions directly under oath. The president says Ukraine felt no pressure, that soliciting these investigations wasn't improper. Is that true? If it is true, why is Ukraine publicly saying that the talk of investigations could destroy everything? And if the president's administration thought this was okay, why did you use the words drug deal? We should ask him that. Why did you urge your staff to report concerns to lawyers? These are all questions that we can get the answers to. Third, the president has suggested the House managers have not presented any direct evidence about Mr. Giuliani's role in the scheme.
In fact, it appears the House committee wasn't particularly interested in presenting you with any direct evidence of what Mayor Giuliani did or why he did it. Instead, they ask you to rely on hearsay, speculation, and assumption, evidence that would be inadmissible in any court.
Well, once again, that's simply not true. But if you want more evidence, we know that Ambassador Bolton has direct evidence of Mr. Giuliani's role regarding Ukraine and expressed concerns about it. The president has suggested that Mr. Giuliani wasn't doing anything improper, and he was not involved in conducting policy. By their own admission, they said he wasn't doing policy. So let's ask John Bolton what Giuliani was doing and whether the investigations were politically motivated or part of our foreign policy. He would know. Dr. Hill testified that Ambassador Bolton said Mr. Giuliani was, quote, a hand grenade, which she explained referred to, quote, all of the statements that Mr. Giuliani was making publicly, that the investigations that he was promoting, that the storyline he was promoting, the narrative he was promoting was going to backfire, end quote. The narrative Mr. Giuliani was promoting, of course, was asking Ukraine to dig up dirt on Biden. Dr. Hill also testified that Ambassador Bolton was so concerned, he told Dr. Hill and other members of the NSC staff, quote, nobody should be meeting with Giuliani, end quote. And that was, quote, closely monitoring what Mr. Giuliani was doing and the messaging that he was sending out, end quote. So let's ask Ambassador Bolton. If Mr. Giuliani wasn't doing anything wrong, why were you so concerned about his behavior? That you directed your staff to have no part in this. If Mr. Giuliani wasn't trying to dig up dirt on Biden, why did you seem to think he was, that he could, quote, blow everything up? Fourth, the president has said that there was nothing wrong with the July 25th call. But once again, the evidence suggests that Ambassador Bolton would testify that the opposite is true. According to witness testimony, Ambassador Bolton expressed concerns even before the call that it would be, quote, a disaster, because he thought there would be, quote, talk of investigations or worse. Now, if the president would have you believe that the call was perfect, as he's repeatedly stated, why don't we find out? Because all of the evidence before you suggests otherwise. And Ukraine knows this is not the case. The call was not perfect. Denny Look is clear on this point. He said, quote, one thing I can tell you that was clear from this July 25th call is that the issue of the investigations is an issue of concern for Trump, end quote. Or it was clear. But if there's still any uncertainty, we must ask Ambassador Bolton. If there was no scheme, how did you know President Trump would raise investigations on the call? What made you so concerned a call would be a disaster? Fifth, the president's main defense, once again, is that he withheld the military aid for a legitimate reason. But the evidence doesn't support that. We've heard a lot. The evidence doesn't support that. Witness testimony, emails, and other documents confirm that Ambassador Bolton and his subordinates on many occasions, including through in-person meetings with the president himself, urged the president that there was no legitimate reason to withhold the aid. But if you're not sure, if you think this could in any way have been about a legitimate policy reason, let's ask the National Security Advisor, who was in charge of that. If this was simply a policy dispute, as the president argues, let's ask John Bolton whether that's true. The president also argues that you cannot evaluate the president's subjective intent, that the president can use his power any way he feels is appropriate. That's, of course, not the case. Whether his intent was corrupt is a central part of this case, as it is in nearly every criminal case in the country. As a backup argument, however, the president claims that we want you to read the president's mind. Juries, of course, are routinely...
entire impeachment process is about the House manager's insistence that they are able to read everybody's thoughts, they can read everybody's intention.
Keenly asked to determine the defendant's state of mind. That's central to almost every criminal case in the country. It's disingenuous for the president's counsel to argue that the defendant's state of mind is unknowable, that it requires a mind reader, or is anything but the most common element of proof of any crime, constitutional or otherwise. But if you want more information, let's ask the president whether John Bolton can help fill in any gaps about his state of mind.
If you think about it, John, he knows some of my thoughts. He knows what I think about leaders.
Case is about the president's conduct in Ukraine. John Bolton knows a lot about that. Let's hear from him. A fair trial demands it. And it's more than just ensuring a fair trial. It's about remembering that in America, truth matters. As Mr. Bolton said on January 30th, quote, "The idea that somehow testifying to what you think is true is destructive to the system of government we have, I think is very nearly the reverse. The exact reverse of the truth," end quote. Now, as Manager Schiff started this out, the truth continues to come out. Again, in an article today, more information. The truth will come out, and it's continuing to. The question here of this body is, what do you want your place in history to be? Do you want your place in history to be, let's hear the truth, or that we don't want to hear it?
Given our time constraints, we will now summarize the reasons why Mr. Mulvaney, Mr. Duffy, and Mr. Blair are also important. Let's turn first to Mr. Mulvaney. To begin with, Mr. Mulvaney participated in meetings and discussions with President Trump at every single stage of this scheme. We just talked about motive and intent. Well, if you want further insight into the president's motives or intent, further direct evidence of why he withheld the military aid in the White House meeting, you should call his acting chief of staff, who had more access than anyone. Mr. Mulvaney is important because the president's counsel continues to argue incorrectly that our evidence is just hearsay and speculation.
It isn't correct.
Faced with Ambassador Sondland and Mr. Holmes saying this was all as clear as 2 + 2 = 4, the president says they are just guessing. That is simply not true. The evidence is direct. The evidence is compelling and confirmed by many witnesses, corroborated by text messages, emails, and phone records. But if you want more evidence, if you want another firsthand account for why the aid was withheld, for the undisputed quid pro quo for that White House meeting, let's just hear from Mick Mulvaney. Over and over again, Ambassador Sondland described to multiple witnesses how Mr. Mulvaney was directly involved in the president's scheme. Here's some of that testimony.
And so when I came in, Gordon Sondland was basically saying, well, look, we have a deal here that there will be a meeting. I have a deal here with Chief of Staff Mulvaney. There will be a meeting if the Ukrainians open up or announce these investigations and into 2016 in Burisma. And I cut it off immediately there. Ambassador Bolton told me that I am not part of this whatever drug deal that Mulvaney and Sondland are cooking up.
What did you understand him to mean by the drug deal that Mulvaney and Sondland were cooking up?
I took it to mean investigations for a meeting.
Did you go speak to the lawyers?
I certainly did.
What I want to ask you about is he makes reference in that drug deal to a drug deal cooked up by you and Mulvaney. It's the reference to Mulvaney that I want to ask you about. You've testified that Mulvaney was aware of this quid pro quo, of this condition that the Ukrainians had to meet, that is announcing these public investigations to get the White House meeting. Is that right?
Yeah, a lot of people were aware of it, and
including Mr. Mulvaney.
Correct.
Remarkably, the president is still denying the facts.
Remarkable.
Even as
No,
they
he
argue
that's what he does.
that if it's true, it's still not impeachable. But if the president did nothing wrong, if he held up the aid because of so-called corruption or burden sharing reasons, he should want his chief of staff to come testify under oath before this distinguished body and say just that. Why doesn't he want Mulvaney to appear before the United States Senate? Well, we know the answer. Because Mr. Mulvaney will confirm the corrupt shakedown scheme. Because Mr. Mulvaney was in the loop. Everyone was in the loop. As Ambassador Sondland summarized in his testimony on July 19th, he emailed several top administration officials, including Mr. Mulvaney, that President Zelensky was prepared to receive POTUS's call and would assure President Trump that he intends to run a fully transparent investigation and will turn over every stone. Mr. Mulvaney replied, "I asked NSC to set it up for tomorrow." The above email seems clear. Ambassador Sondland testified that it was clear, that he was confirming to Mr. Mulvaney that he had told President Zelensky he had to tell President Trump on that July 25th call that he would announce the investigation, which he explained was a reference to one of the two phony political investigations that President Trump wanted. And Mr. Mulvaney replies that he'll set up the meeting, consistent with the agreement that Sondland explained he'd reach with Mr. Mulvaney to condition a meeting on the investigations. But if there's any uncertainty, if there's any lingering questions about what this means, let's just question Mick Mulvaney under oath. Mr. Mulvaney also matters because we have heard several questions from this distinguished body of senators wanting to understand when or why or how the president ordered the hold on the security aid. As the head of the Office of Management and Budget, Mr. Mulvaney has unique insights into all of these questions. Your questions. Remember that email exchange between Mr. Mulvaney and his deputy, Rob Blair, on June 27th, when Mulvaney asked Blair about whether they could implement the hold? And Blair responded that it could be done, but that Congress would become unhinged. It wasn't just Congress. It was the Independent Government Accountability Office that determined that the president's hold violated the law. But if the president's counsel is going to argue without evidence that he withheld the aid as part of U.S. foreign policy, seems to make sense that the Senate should hear directly from Mr. Mulvaney, who has firsthand knowledge of exactly these facts. He said so himself.
Again, I was involved with the process by which the money was held up temporarily. Okay.
Why doesn't President Trump want Mick Mulvaney to testify? Why? Perhaps here's why.
Did he also mention to me in the past the corruption related to the DNC server? Absolutely, no question about that. But that's it, and that's why we held up the money. Now there was a report.
So the demand for an investigation into the Democrats was part of the reason that it was ordered to hold funding to Ukraine.
The look back to what happened in 2016 certainly was part of the thing that he was worried about in corruption with that nation, and that is absolutely appropriate.
But to be clear, what you just described is a quid pro quo. It is funding will not flow unless the investigation into the Democratic server happened as well.
We do that all the time with foreign policy. We were holding up money at the same time for what was it? The Northern Triangle countries.
No, but
we're holding up aid at the Northern Triangle countries so that they would change their policies on immigration. By the way, and this speaks to an important. I'm sorry. This speaks to an important point because I heard this yesterday. I can never remember the gentleman who testified. McKinney, the guy, is that his name? I don't know him. He testified yesterday. And if you believe the news reports, okay, because we've not seen any transcripts of this. The only transcript I've seen was Sondland's testimony this morning. If you read the news reports and you believe them, what did McKinney say yesterday? Well, McKinney said yesterday that he was really upset with the political influence in foreign policy. That was one of the reasons he was so upset about this. And I have news for everybody. Get over it. There's going to be political influence in foreign policy.
Is that what the Constitution requires? Get over it? Is that good enough for this body? The world's greatest deliberative body? Get over it? The President's Counsel can try to emphasize Mr. Mulvaney and his attorney's efforts to walk back this statement. But as you've seen with your own eyes, the statement was unequivocal. And even when given the chance in real time on that day, on October 17th, to deny a quid pro quo, he doubled down. Get over it, he said. But if you have any questions about what the real answer is, where the truth lies, there's only one way to find out. Let's all just question Mr. Mulvaney under oath during a Senate trial. After all, counsel said that cross-examination was the greatest vehicle in the history of American jurisprudence ever invented to ascertain the truth. Your standard. Finally, I'd like to touch briefly on the importance of Mr. Blair and Mr. Duffy to this case. The president's lawyers have argued that withholding foreign aid is entirely within his right as commander-in-chief, that this was a normal, ordinary decision, and that this is all just one big policy disagreement. We have proven exactly the opposite. This can't be a policy disagreement because the president's hold actually went against U.S. policy. The hold was undertaken outside of the normal channels by a president who they admit was not conducting policy. The hold was concealed not only from Congress, but from the president's own officials responsible for Ukraine policy. And most importantly, the hold violated the law. The president has the right to make policy, but he does not have the right to break the law and coerce an ally into helping him cheat in our free and fair elections. And he doesn't have a right to use hundreds of millions of dollars in taxpayer funds as leverage to get political dirt on an American citizen who happens to be his political opponent. But if you remain unsure about all of this, who better to ask than Mr. Blair or Mr. Duffy? They oversaw and executed the process of withholding the aid. They can tell us exactly how unrelated to business as usual this whole shakedown scheme was when it was underway. They can testify about why the aid was withheld and whether there was any legitimate explanation for withholding it. Some of you have asked that very question. Multiple officials, including Ambassador Sondland, Ambassador Taylor, David Holmes, Lieutenant Colonel Vindman, Jennifer Williams, and Mark Sandy, all testified that they were never given a credible explanation for the hold. So let's ask Mr. Blair, let's ask Mr. Duffy if this happens all the time, as Mick Mulvaney suggests. Why at this time, in connection with this scheme, were all of those witnesses left in the dark? Despite the president's refusal to produce a single document, to produce a shred of information in this impeachment inquiry undertaken in the House, his administration did produce 192 pages of Ukraine-related email records in Freedom of Information Act lawsuits, albeit in heavily redacted form. These documents confirm Mr. Duffy's central role in executing the hold. He's on nearly every single email released. Nearly every single email. Here's an important email from that production. Just 90 minutes after the July 25th call, Mr. Duffy emailed officials at the Department of Defense that they should hold off on any additional DoD obligations of these funds. Mr. Duffy added that the request was sensitive and that they should keep this information closely held. The timing is important because if the aid wasn't linked to the July 25th call, if it wasn't related, why the sensitive, closely held request made within 2 hours of that call? Let's just ask Mr. Duffy. Mr. Duffy and Mr. Blair can testify about the concerns raised by DoD to the Office of Management and Budget, about the illegality of the hold, and why it remained in place even after DoD warned the administration that it would violate the Impoundment Control Act. Now, the president, of course, has disputed this fact. But we have demonstrated that OMB was warned repeatedly by DoD officials of two things. First, continuing to withhold the aid would prevent the Department of Defense from spending the money before the end of the fiscal year. And second, the hold was potentially illegal, as turned out to be the case. By August 9th, DoD told Mr. Duffy directly that DoD, the Department of Defense, could no longer support the Office of Management and Budget's claims that the hold would not preclude timely execution of the aid for Ukraine, our vulnerable ally at war with Russian-backed separatists. Yet, as Mr. Duffy reportedly told Ms. McCusker at the Department of Defense on August 30th, there was a clear direction from POTUS to continue the clear direction from the President of the United States to continue the hold.
Can't do that, dude.
So how did Mr. Duffy understand the clear direction? to continue the hold? Why is the president claiming that this wasn't unlawful when DOD, the Department of Defense, repeatedly warned his administration that it was? Wouldn't we all like to ask Mr. Duffy these questions? Finally, here's another reason why we know this was not business as usual. On July 29th, Mr. Duffy, a political appointee with zero relevant experience, abruptly seized responsibility for withholding the aid from Mark Sandy, a career Office of Management and Budget official. Seized the responsibility from a career official. Mr. Duffy provided no credible explanation for that decision. Mr. Sandy testified that nothing like that had ever happened in his entire governmental career. Let's think about that. If this is as routine as the president claims, why is a career official saying he's never seen anything like this happen before? Mr. Duffy knows why. Shouldn't we just take the time to ask him? The American people deserve a fair trial. The Constitution deserves a fair trial. The president deserves a fair trial. A fair trial means witnesses. A fair trial means documents. A fair trial means evidence. No one is above the law. I now yield to my distinguished colleague, Manager Lofgren.
Mr. Chief Justice and Senators, it's not just about hearing from witnesses. You need documents. The documents don't lie. There are specific documents relevant to this impeachment trial in the custody of the White House, OMB, DOD, and the State Department, and the president has hidden them from us.
Yeah.
I'm not going to go through each
That's
category
obstruction,
again in
man.
detail, but here are some observations. This is, of course, an impeachment case against the President of the United States. Nothing could be more important. And the most important documents that go directly to who knew what when, are being held by the executive branch. Many of these records are at the White House. The White House has records about phone calls with President Zelensky, about scheduling an Oval Office meeting with President Zelensky, about the president's decision to hold security assistance, about communications among his top aides, about concerns raised by public officials with legal counsel. We've heard about Ambassador Bolton's handwritten notes and book manuscript and Lieutenant Colonel Vindman's presidential policy memorandum. We know of reports about a number of emails in early August trying to create after-the-fact justifications for the hold, but we haven't seen any of them. They're at the White House, being hidden by the president. I think it's a cover-up. Documents at the State Department. Records about the recall of Ambassador Yovanovitch, about Mr. Giuliani's efforts for the president, about concerns raised about the hold, about the Ukrainian reaction to the hold, and when exactly they learned about it. About negotiations with the Ukrainians for an Oval Office meeting. We know of Ambassador Taylor's first-person cable and notes and Mr. Kent's memos to file. We know about Mr. Sondland's emails with Pompeo and Breckbull and Mulvaney and Perry, but we haven't seen them. They're sitting at the State Department. DOD and OMB also have records about President Trump's hold on military aid to Ukraine, about the justification for the hold, about hiding the hold from Congress and trying to justify the hold after the fact, and about why the hold was lifted, but we haven't seen them. They're at DOD and OMB. Why haven't we seen them? Because the president directed all of his agencies not to produce them. This trial should not reward the president's really unprecedented obstruction by allowing him to control what evidence you see and what will remain hidden. You should ask for these documents on behalf of the American people, and you should ask for these documents to get the truth yourself. Now let's come back to the issue of delay, since the president's lawyers have suggested that having witnesses and documents would make this trial take too long. There will be lengthy court battles, they say. The president might even invoke executive privilege for the very first time in this entire impeachment
ridiculous.
process.
He doesn't even.
It would be better, we're told, to skip straight to the final verdict, to break from centuries of precedent and end this trial without hearing from a single witness, without reviewing a single document that the president ordered hidden. Respectfully, that shouldn't happen. House managers aren't interested in delaying these proceedings. We're interested in the full truth, in a trial that is fair to the parties and to the American people, in the facts that the President's Counsel agrees are so critical to this trial. It's why we've said we won't go to court. We'll follow all the rulings of the Chief Justice. We can get the witness depositions done in a week. In fact, I know we can, because if you, the senators, order it, that's the law. You have the sole power to try impeachments. If questions or objections come up, including objections based on executive privilege, the Senate itself and the Chief Justice in the first instance can resolve them. We aren't suggesting that the president waive executive privilege. We simply suggest that the Chief Justice can resolve issues related to any assertion of executive privilege. As the Supreme Court recognized in the case of Judge Walter Nixon, judges will stay out of disputes over how the Senate exercises its sole power to try impeachments. That ensures there will be no unnecessary delay, and it's why we propose we suspend the trial for 1 week, and that during that time, you go back to business as usual. While the trial is suspended, we'll take witness depositions, review the documents that are provided at your direction. The 4 witnesses you should hear from are readily available. Ambassador Bolton has already said he will appear. We can and would move quickly to depose these witnesses within a week of the issuance of subpoenas. The documents, too, are ready to be produced. We're ready to review them quickly and to present additional evidence. Meanwhile, the Senate can continue going about its important legislative work as it did during the depositions in the Clinton impeachment trial. The president's opposition to this suggestion says a lot. The president is the architect of the very delay he warns against. He could easily avoid it. He could move things along. He could stop trying to silence witnesses and hide evidence. I think he's afraid the truth will come out. He hopes his threats of continued delay, however unjustified, will cause you to throw up your hands and give up on a fair trial. Please don't give up. This is too important for our democracy. A decision to forego witnesses and documents at this trial would be a big departure from Senate precedent. When the Senate investigated Watergate, it heard from the highest White House officials. That happened because a bipartisan majority of the Senate insisted. We got to the truth then because the Senate came together and put a fair proceeding above party loyalty. We should all want the truth. And so we ask you, do it again, that you put aside any politics, party loyalty, belief in your president, which we understand and sympathize with, but subpoena the documents and the witnesses necessary to make this a fair trial, to hear and see the evidence you need to impartially administer justice. Now, there's been a lot of discussion of executive privilege during this trial. Even if the president asserts executive privilege, something he has not yet done, it wouldn't harm the president's legal rights or cause undue delay, and here's why. Let's focus on John Bolton, since this week's revelations confirm the importance of his testimony. First, as a private citizen, John Bolton is fully protected by the First Amendment if he wants to testify. There's no basis for imposing prior restraint for censoring him just because some of his testimony could include conversations with the president. That's commonplace. As long as his testimony isn't classified, it is shielded by the free speech clause, by the First Amendment. Ambassador Bolton has written a book. It's inconceivable that he is forbidden from telling the United States Senate, sitting as a high court of impeachment, information that shortly will be in print. If the president did attempt to invoke executive privilege, he would fail. It's true for two separate reasons. First, claims of executive privilege always involve a balancing of interests. The Supreme Court confirmed in U.S. v. Nixon, the Nixon tapes case, that executive privilege can be overcome by a need for evidence in a criminal trial. That is even more true here in an impeachment trial of the President of the United States, which is probably the most important interest under the Constitution. It would certainly outweigh any claim of privilege. Precedent confirms the point. To name just a few, national security advisors for President Carter, Zbigniew Brzezinski, President Clinton, Samuel Berger, President George W. Bush, Condoleezza Rice, and President Obama, Susan Rice, testified in congressional investigations. These advisors discussed their communications with top government officials, including the presidents they served. There's no reason why all of these officials could testify in the normal course of events and hearings, but Ambassador Bolton, a former official, couldn't testify in the most important trial there could possibly be. The second reason is the president waived any claim of executive privilege about Ambassador Bolton's testimony. All 17 witnesses testified in the House about these matters without any assertion of privilege by the president. President Trump, as well as his lawyers and senior officials, have publicly discussed and tweeted about these issues at some length. The president has also directly denied reports about what Ambassador Bolton will say in his forthcoming book. Under these circumstances, the president cannot be allowed to tell his version of the story to the public while using executive privilege to silence a key witness who would contradict him. You shouldn't let the president escape responsibility only to later see clearly what happened in Ambassador Bolton's book. There are no national security risks here. The president has declassified the 2 phone calls with President Zelensky. All 17 witnesses testified about the president's conduct regarding Ukraine. We aren't interested in asking about anything other than Ukraine. That's simply a bogus argument. The Constitution uses the word sole power only twice. First, when it gives the House sole power to impeach. And second, Article 1, Section 3, where it gives the Senate sole power to try impeachments. And here's what it says. The Senate shall have the sole power to try all impeachments. When the President of the United States is tried, the Chief Justice shall preside. Now, I think that provision in the Constitution means something. It's up to the Senate to decide how to impeachment with fairness, with witnesses, and documents. Privileges asserted can be decided using the process that you devise. That's not unconstitutional. It's what the Constitution provides. You have the power. You decide. Please decide for a fair trial that will yield the truth and serve our Constitution and the American people. I yield now to Manager Schiff.
That was wonderful. That's Representative Zoe Lofgren. She's from California, a Democrat. She has the unique situation of being someone who was in or on the Hill during Nixon, Clinton, and now Trump impeachments, all 3.
Senators, before we yield to counsel with the president, I'd like to take a moment by talking about what I think is at stake here. A no vote on the question before you will have long-lasting and harmful consequences long after this impeachment trial is over. We agree with the President's counsel on this much. This will set a new precedent. This will be cited in impeachment trials from this point to the end of history. You can bet in every impeachment that follows, whether it is a presidential impeachment or the impeachment of a judge, if that judge or president believes that it is to his or her advantage that there shall be a trial with no witnesses, they will cite the case of Donald J. Trump. They will make the argument that you can adjudicate the guilt or innocence of the party who is accused without hearing from a single witness, without reviewing a single document. And I would submit that will be a very dangerous and long-lasting precedent that we will all have to live with. President Trump's wholesale obstruction of Congress strikes at the heart of our Constitution and democratic system of separation of powers. Make no mistake, the president's actions in this impeachment inquiry constitute an attack on congressional oversight, on the co-equal nature of this branch of government. Not just on the House, but on the Senate's ability as well to conduct its oversight, to serve as a check and balance on this president and every president that follows. If the Senate allows President Trump's obstruction to stand, it effectively nullifies the impeachment power. It will allow future presidents to decide whether they want their misconduct to be investigated or not, whether they would like to participate in an impeachment investigation or not. That is a power of the Congress. That is not a power of the president. By permitting a categorical obstruction, it turns the impeachment power against itself. How do we respond to this unprecedented obstruction will shape future debates between our branches of government and the executive forever. And it's not just impeachment. The ability of Congress to conduct meaningful and probing oversight that by its nature is intended to be a check and balance on the awesome powers of the executive branch, hinges on our willingness to call witnesses and compel documents that President Trump is hiding with no valid justification, no precedential support. If we tell the president effectively, you can act corruptly, you can abuse the powers of your office to coerce a foreign government to helping you cheat in an election by withholding military aid, and when you're caught, you can further abuse your powers by concealing the evidence of your wrongdoing, the president becomes unaccountable to anyone. Our government is no longer a government with three co-equal branches. The president effectively, for all intents and purposes, becomes above the law. This is, of course, the opposite of what the framers intended. They purposely entrusted the power of impeachment to the legislative branch so that it may protect the American people from a president who believes that he can do whatever he wants. So we must consider how our actions will reverberate for decades to come and the impact they will have on the functioning of our democracy. And as we consider this critical decision, it's important to remember that no matter what you decide to do here, whether you decide to hear witnesses and relevant testimony, the facts will come out in the end. Even over the course of this trial, we have seen so many additional facts come to light. The facts will come out. In all of their horror, they will come out. And there are more court documents and deadlines under the Freedom of Information Act. Witnesses will tell their stories in future congressional hearings, in books, and in the media. This week has made that abundantly clear. The documents the president is hiding will come out. The witnesses the president is concealing will tell their stories. And we will be asked why we didn't want to hear that information when we had the chance. Okay. When we could consider its relevance and importance in making this most serious decision. What answer shall we give if we do not pursue the truth now? If we allow it to remain hidden until it is too late to consider on the profound issue of the president's innocent or guilt? What we are asking you to do on behalf of the American people is simple. Use your sole power to try impeachment by holding a fair trial. Get the documents they refuse to provide to the House. Here are the witnesses they refuse to make available to the House, just as this body has done in every single impeachment trial until now. Let the American people know that you understand they deserve the truth. Let them know you still care about the truth, that the truth still matters. Though much divides us, on this we should agree. A trial stripped of all its trappings should be a search for the truth, and that requires witnesses and testimony. Now, you may have seen just this afternoon, the president's former chief of staff, General Kelly, said a Senate trial without witnesses is a job only half done. Trial without witnesses is only half a trial. Well, I have to say I can't agree. Trial without witnesses, no trial at all. You either have a trial or you don't. And if you're going to have a real trial, you need to hear from the people who have firsthand information. Now, we presented some of them to you, but you know as well as we, there are others that you should hear from. But let me close this portion with words I think more powerful than General Kelly's, and they come from John Adams, who in 1776 wrote, "Together with the right to vote, those who wrote our Constitution considered the right to trial by jury the heart and lungs, the mainspring and the center wheel of our liberties, without which the body must die, the watch must run down, the government must become arbitrary." Now, what does that mean? Without a fair trial, the government must become arbitrary. Now, of course, he's talking about the right of an average citizen to a trial by jury. Well, if in courtrooms all across America, when someone is tried, but they're a person of influence and power, they could declare at the beginning of the trial, if the government's case is so good, let them prove it without witnesses. If people of power and influence can insist to the judge that the House, that the prosecutors, that the government, that the people must prove their case without witnesses or documents, a right reserved only for the powerful. Because you know, only Donald Trump of any defendant in America can insist on a trial with no witnesses. If that should be true in courts throughout the land, then as Adams wrote, the government becomes arbitrary. Because whether you have a fair trial or no trial at all depends on whether you are a person of power and influence like Donald J. Trump. The body will die, the clock will run down, and our government becomes arbitrary. The importance of fair trial here is not less than in every courtroom in America. It is greater than in any courtroom in America, because we set the example for America. I said at the outset, and I'll repeat again, your decision on guilt or innocence is important, but it's not the most important decision. If we have a fair trial, however that trial turns out, whatever your verdict may be, at least we can agree we had a fair trial. At least we can agree that the House had a fair opportunity to present its case. At least we can agree that the president had a fair opportunity to present their case, if we have a fair trial. And we can disagree about the verdict, but we can all agree the system worked as it was intended. We had a fair trial and we reached a decision. Rob this country of a fair trial, and there can be no representation that the verdict has any meaning. How could it, if the result is baked in by the process? Assure the American people, whatever the result may be, that at least they got a fair shake. There's a reason why the American people want to hear from witnesses. And it's not just about curiosity. It's because they recognize that in every courtroom in America, that's just what happens. And if it doesn't happen here, the government has become arbitrary. There is one person who is entitled to a different standard, and that's the President of the United States. And that is the last thing the founders intended.
And Donald
We
J.
reserve the
Trump
balance
just
of our
did.
time.
Thank you, Mr. Manager.
Mr. Chief
The
Justice,
majority leader is
I
recognized.
request the Senate take a 15-minute recess.
Without ordered.
So there we go. Donald Trump seems to have pulled it off. What can we say about that? He's always been audacious and arrogant, brash about the fact that he does whatever he wants. He has said he could walk down Fifth Avenue and shoot someone and get away with it. He says, when you get rich and famous like him, women just let you grab them by their bodies. He said disgusting things about what he can do and get away with. And his arrogance is about to be rewarded by the Senate, from what I can tell.
Good morning, everybody. I'm proud to be joined by my colleagues this morning. Now, as everyone knows, for months now, we Democrats have relentlessly asked to hear from relevant witnesses and review relevant documents in this trial for a very simple reason. This is about truth. And today, the Senate will vote on whether witnesses and documents are allowed in this trial. The importance of this vote is self-evident. Trials have witnesses. Trials have documents. The vote today is about whether the Senate will have a fair trial of the President of the United States. So it's deeply disturbing that on something of such importance to the future of our democracy, a few of my Republican colleagues announced last night they vote against hearing additional evidence. It's clear where the American people stand on the issue. Republican senators who decide to go against the will of the people will have to reckon with it. The result of today's vote is still an open question. But I would note that even in Senator Alexander's statement announcing his opposition to new evidence, he said that it was proven that the president did what he was accused of. He came to the wrong conclusion about hearing evidence in this trial. That's clear. But Senator Alexander, a senior Senate Republican, a retiring member, said out loud that I think most Senate Republicans believe in private. That yes, the president did withhold military assistance to try to get Ukraine to help him in his elections. And yes, the president did interfere with congressional investigations of that misconduct. He said, yes, the president conditioned foreign aid and a White House meeting with an ally at war on the performance of bogus investigations that would help his reelection. Alexander rejected 90% of the argument from the president's counsel that the president did nothing wrong. He acknowledged that the president did something that the founders feared most: the potential corruption of our national elections by a foreign power, solicited by none other than our own president. And to hide that gross misconduct, the White House exhausted every legal trick in the book to prevent Congress from investigating. If my Republican colleagues refuse to even consider witnesses and documents in this trial, this country is headed towards the greatest cover-up since Watergate. If my Republican colleagues refuse to even consider witnesses and documents in the trial, what will the president conclude? We all know he'll conclude he can do it again, and Congress can do nothing about it. He can try to cheat in his election again, something that eats at the roots of our democracy. And one more point, a point I've been making for weeks, but is most relevant today. If my Republican colleagues refuse to consider witnesses and documents in this trial, the president's acquittal will be meaningless because it will be the result of a sham trial. If there are no witnesses, no documents in this trial, there will be a permanent asterisk next to the acquittal of President Trump written in permanent ink. So, Senate Republicans face a choice today between seeking the truth and covering it up, between a fair trial and a farce, between country and party. No matter what the results of today's vote, I believe the truth will eventually come out. My Republican colleagues should think about that before they vote today. The truth will eventually come out. We could vote to see the truth in this trial, or it could come out in a few weeks or a few months. And on that day, every Republican who voted to hide the truth in an impeachment trial of the president will have to answer for it. Senator Murray.
That from Senator Chuck Schumer, the Senate Democratic leader, at about 11:20 this morning. It's now approaching 3 o'clock here in Washington, D.C. A short break between the arguments put forth by the Democratic impeachment manager, Adam Schiff of California, and we expect to hear from the president's attorneys after the break. Here's Senator Schumer live at the Senate basement. Let's listen to see if he comes to the microphone to talk.
Okay, I'm going to be rather brief. Look, at 11 o'clock this morning, I was upstairs and we said there's certainly going to be more revelations that come out. Little did we know that an hour later, a thunderbolt struck. John Bolton sat in the room with Mr. Mulvaney, Cipollino, and they talked all about withholding aid and letting the Ukrainian president know. More and more evidence comes out. It will. No mistake about it. What happened today won't be the only or even the most significant and important leak that comes out, because that's just how it is. When you have so many, one of the most troubling things about this is what the president did was so wrong, and there were so many people in the loop, all of whom shrugged their shoulders and went along with something that was decidedly against the law. Maybe they said to themselves, well, that's who Donald Trump is. That's who we're working for. But when there are so many people in the loop, there are so many revelations from that loop as time goes on. And so, no, folks. And so that it is devastating. As for, there is no agreement between Leader McConnell and myself. We have stood for one thing. We do not want this rushed through. We do not want it in the dark of night. Members have an obligation to tell the American people and to tell the people of their states why they are voting. So we are going to use whatever power we have to prevent it from being rushed through. But right now there is no agreement. I'm not going to take any questions.
Well, there you have it. That's the minority leader.
That very brief statement.
And what we're going to do is, right around these times is when C-SPAN will go to their phone calls. And during these 11 or however many I've made of these, I've occasionally let the phone calls roll in, but sometimes they're not really very good. And often they're inflammatory, so I'm not going to do that. But there is one that was in one of them by a former prisoner that was very moving, and I'm going to go find that and make a clip out of it. Now, what I'm going to do here is, oh, they're talking about
managers now speaking to reporters.
1999, there was a 100-0 vote against witnesses. Chuck Schumer was one of.
Yeah, so we're turning that off. And we're going to restart it. And I'm going to restart this as well because this has a setting where it just automatically goes off every 2 hours. So what we're doing is we're getting ahead of that. And that'll also let us set up another program here. That'll be part 2 of day 11. The notion that Donald Trump can basically get away with it is what I'm trying to process, and it's very hard for me to get my head around, if I'm honest. The scale of the corruption in this country and the power of the wealthy is just something quite staggering to me some days. And it's very sad. It makes me sad. Makes me quite sad. Those are the last words from the minority leader there. There is no agreement. Between Majority Leader McConnell and Minority Leader Schumer. Oh boy, folks. All right, well, I'm going to shut this down and we'll restart when they do. All right, thanks.